Good evening, everybody, and welcome to another edition of the South Florida Tribune podcast. My name is Scott Morgan, the Motor City Mad Mouth, and I feel like this is a broadcast called All the President's Men. All the President's Men. We got David Levin in the house. David, how you feeling?
Hey, guys. How y'all doing tonight? It's glad to be back and ready to talk a little bit of legal issues and how they relate to what we're going on today.
And our legal analyst, Ron Renzy, double R, otherwise known as, in the math world, R Square. What's up, Ron?
Hey, Scott. It's a pleasure to be here, as always.
Oh, we love having you guys on. So we're going to get there and talk about Florida tort law. So, Ron Renzy, why don't you educate everybody about what Florida tort law is?
Sure, Scott. It's a pleasure to do so. Good background. Well, starting out simply, if a civil suit is not covered by a contract, it's not covered by a statute, in Florida, it's going to be a tort. What tort law is in Florida, it relates to essentially any civil case where a party bringing the action is seeking compensation for damages. Torts are just another word for a civil wrong that causes harm. No, it's not a French cake, as a lot of folks say. Generally, the harm is some sort of personal or economic injury, depending on the tort, and the victim of the tort, the one hurt, is seeking financial damages because of that injury. So it's a purely civil case, not a criminal case, not a family law case. Damage in a civil case can be anything, including lost wages, lost business income, lost profits, sometimes mental, physical pain, and sometimes even pain and suffering or medical bills. A party bringing the lawsuit, which is the plaintiff, seeks damages that have occurred in the past, and any damages are reasonably certain to occur in the future. So what's a tort? It includes all kinds of things. It includes negligence. It includes misrepresentation. It includes libel or slander, trespass, intentional infliction of emotional stress, and many other things. So torts can be caused by intentional wrongdoing of somebody, the negligent wrongdoing, or some kind of strict liability. So, yes, torts exist in all states. They differ a little bit from state to state, but Florida, like all other states, is a common law state. Briefly, common law means that judges are required to follow the precedent as a result of decisions of higher courts. Thus, a trial court in Florida is required to follow the appellate decisions of the Florida District Courts of Appeal, as well as the Supreme Court of Florida and the United States Supreme Court. Judges are also required to follow the statutes passed by the Florida legislature or federal laws that are passed by Congress. And why is common law important? Because tort law is common law. It's not laid out in a law, in a statute. It actually involves some old English common law, and that's why it's a wrong considered a tort that may be compensated if somebody wins a suit. Hopefully that's making some sense so far. Let's give a couple examples. Why not? The most widely known kind of tort is negligence. That's the one everybody thinks of. We see the commercials all the time. Have you been injured by the fault of someone else? Call us. Most people think of negligence as personal injury, like a car accident or slip and fall. You fall in a grocery store, that's a tort. But there can also be in other contexts, such as in the business context. Yes, there can be negligence in the business context. And that's talking about negligence, and any kind of negligence, whether it's a business, a slip and fall, car accident, anything, malpractice, medical malpractice, whatever it is. There's 4 distinct elements that if you sue, you have to bring forth in your case and you have to prove, which is the plaintiff. The plaintiff has to show that the responsible party had a legal obligation to act with reasonable care so not to cause harm. Well, a duty, believe it or not, we all assume duties. When we drive down the road, Scott, you assume a duty to drive in a reasonable manner, not to be negligent. I know you're not, but some people are. Now, once you...
Well, it depends on what part of I-75 I'm on. Depends on what part of I-75 I'm on, or I-95, or if I'm on a racetrack. But yeah, Ron, that's okay. If I ever get in trouble, I know to call you anyways. But go ahead, continue your
That's
thought.
right. That's if you're on a racetrack.
Little light foot there.
Well, you know.
Well, I just thought of Scott because I know he does a lot of driving. He does it very well. He is not the guy that's negligent. There's a lot of other people out there negligent. Now, the second thing.
Well, there are worse people than me, that's for sure.
The plaintiff has to show that the person or entity breached the duty, meaning the other person wasn't careful. Or let's look at the grocery store. They have a duty to clean up. They don't want to spill apple juice all over the floor. David comes along and slips and flies 5 feet in the air. That would be the breach of the duty. Causation. The plaintiff must present facts that demonstrate a link between the breach of the duty and the accident. Meaning, was the apple juice that was fell on, or did David fall 5 rows down? It had nothing to do with what the negligence was. He still has to show it up. He has to prove it up, and they have to show damages. He has to prove sustained loss because of the negligence. Because even if somebody's negligent and something happens, you don't recover unless you were actually suffer damages. Sorry about that. Now, does that make it so sorry? So we got a good driver and we got David on a banana peel. Any other examples you guys want to come up with somebody being negligent?
Well, I'll just say there are a lot of people far worse than I am. That's okay. Go ahead, David.
No, I was just saying, I want to be the one driving. I want Scott to handle this banana peel thing. I injured myself way too much lately. But I see your point. A lot of people, when they think of injuries, a slip and fall, a sidewalk crack, a busted taillight, there are simple things that we see day to day that we don't necessarily think in the greater picture of the law. And we're in such a litigious society that these things are happening every day, probably more so than we're aware of. What I wanted to ask, though, is that, do things change? I said to Scott the notes, so I'll be careful I say this. Our economic times today, the way that things are changing with COVID, the economy, more people out of work, what is going on in society right this moment? Are people being as proactively litigious with these type of things as they have been, or is this something that they're going to other measures to handle?
Well, I think there's a couple of ways to look at that, because I've talked to some of my colleagues that handle personal injuries, and since there's been COVID, believe it or not, there's been less people on the road. So car accident personal injury cases have actually gone down because I assume because there's less accidents. Now, when you're dealing with other stuff, the grocery store stuff, I think that's pretty steady. To kind of get at the heart of your question, I would say, when you say negligence, it's a very inventive area, if you will, because you get the right person with the right attorney. They can come up with, hey, there was this duty and you breached it and we're going to sue you for it. So I think there's a certain amount of creativity going on. Whether that creativity, is good or bad, that's a whole, a discussion I'm not about. I'm not, no, we should get into, but yes, there's creativity is going on.
Dr. James White at Florida State University taught me the greatest lesson I've ever learned, that no matter how flat a pancake is, there is always two sides to it. And I try and preach that to my children as well, that there's always two sides to everything you do. So I know that when you're filing a lawsuit, or there is negligence, or there's a responsibility or a duty or whatever it is, there's always two individuals or two entities that are involved in that. Because people aren't on the road as much, and because there have been issues with the legal system, we're not seeing as many of these cases filed right now, are we? Because, for lack of a better word, they've been shutting the court system down for a while.
Well, yeah, there have been less case files for accidents, stuff like that, and the court systems are operating. They're operating on a virtual platform, pretty much around throughout the state. But yeah, I would agree with that. And I would also agree with the two sides of every story, and that's why we have a court system. That's our adversarial system. That's why we have the juries. You can get, you can have the same set of facts. Something, let's go to the slip and fall scenario. Mm-hmm. The same exact set of facts. You can have two people with two totally different stories. You can have, let's say, the customer walking down, the one that fell, says, look, I didn't see anything. It was just on the floor. I slipped. I did this and that, and I hurt. the store manager could testify, hey, there was no spill there, or there was a spill, but we put signs all over it. We had those orange cones, and we said, please watch out, and the fellow wasn't paying attention. And then it's up to the jury of your peers to decide, well, what's reasonable? And it really doesn't even mean that either one is wrong. Sometimes it's a perspective. Maybe it's an angle that you don't really see well, or there was a noise or something extraneous happened. It happens all the time.
Right, and because of the definition, and like we were talking about before, what could happen in one state, like in Florida, doesn't necessarily, operate in Georgia or Alabama or, neighboring states. It's dependent on what the state laws are. Have you been in a case where there has been a suit like this and it's tried to carry over to two different states? And I know that wasn't one of the questions we were talking about, but it just popped in my mind, so I thought I'd ask.
I haven't personally been involved, but I have seen cases. You get the multi-state litigation. Let's say a product is sold nationwide. Let's say it's a lawn tool or something, and if it's some people got injured, maybe in different states, you're going to have different laws apply on the standards. Whether it's a defective product or not. So something in Georgia and Florida, you could potentially have different outcomes, depending. And a lot of people do forget we're in the federal system, so we're really under two jurisdictions all the time. We're under the federal jurisdiction, obviously, but we're under whatever state we're in, and each state makes their own laws.
Right, but I do know that some of the laws, especially Florida and Georgia, they do mirror each other in the smaller courts, but I mean, they're still separate but different. When you're dealing with these cases, and then we had talked a little bit about it off the air, that could be anything from money that's owed to an individual. It could be a work claim. It could be a slip and fall, like we talked about. It could be just basically anything that is a civil suit, correct? And then it doesn't necessarily matter technically how much money is. If there's a monetary sum, it doesn't matter the sum of the money.
Well, no, that's correct. It's still a civil suit, for whether it's a tort claim, contract claim, or some kind of statutory claim. It's still a civil suit. It doesn't matter the amount of money. Now, it could, depending on the state you're in, the amount of money may decide what part of the court you're in. For instance, in Florida, if it's under $30,000 now, you're in the county court. If it's over $30,000, you're what's called in the circuit court. They're still trial courts. It's just divided up based on the amount and controversy.
And I'll ask this: how often? I wanted to know whether. I don't think it applies now, because anybody basically can file a civil suit like that, a tort. I was going to wonder whether it's age specific, or there are more people that are younger that are getting involved in this. Maybe older people who are being taken for money with scams and things like that. So I'm going to leave that off the table. However, are you finding that it's more small financial gain, or are we finding it that it's more largely a larger gain that is because it still falls under the same guidelines of what a civil suit would be, because a criminal suit is something that is negligent and causes harm, and that's a whole different story, like murder or assault or things like that. So help me out a little bit in understanding that.
Sure. Well, I mean, yes, criminal laws is different than civil law. Criminal law is kind of like you said, a crime, and then it's a state that is prosecuting the individual. The state charges you. In Florida, through the state attorney, they charge you, and then you. Right. It's a whole other body of law, and that's usually a statutory. It can be murder, it can be arson, it can be all kinds of things. In the civil suit, you're basically one person suing another. So whether it's a contract claim, a tort claim, or a statutory claim, it's A suing B. It's you suing Scott, or vice versa. So you have to make a determination whether it's monetarily feasible to do it.
Right.
I mean, yes, and that's we have talked about that in another show about small claims court, and that's set up for the small. That's literally what it says: small claims. Scott owes you $500. you go to small claims court, it's not worth hiring a lawyer. Scott owes you $500,000. It's probably not a good idea to handle the case yourself.
No.
You know, just like you wouldn't want to be your own accountant, you wouldn't want to be your own dentist, you don't want to be your own lawyer when it's big, and that could fall into a lot of different causes of action, because in Florida, as in other states, there are business torts, which are legal causes of action caused by the person or business that has harmed somebody else in some way. These claims can arise after a person or company sustains some type of loss, whether it's a loss of business relationship, profit, or even future business opportunities. So we can't forget that businesses are legal entities too under the law. So a business can sue another business. A business can sue an individual. An individual can sue a business. Individuals can sue an individual. In addition to the negligence that we already talked about, some common business torts include misrepresentation, tortious interference, and breach of fiduciary duty. Let's talk about misrepresentation. This is kind of an easy one. It's also known as fraud. Everybody kind of knows when they or feels when they were defrauded. This cause of action could arise when an entity, whether it's a person or business, makes a false claim to induce a party to perform an alleged obligation. So let's say you misrepresent the value of an item. My bike was used in the Olympics, so therefore it's worth this, and your bicycle was never used in the Olympics. So somebody else relies on that party's performed, but then is harmed by its reliance on the false representation. Maybe they got something that wasn't worth nearly the value. So the plaintiff, the harmed party, would then bring an action for damages against the defendant, the opposing party. Now, to prove misrepresentation, because people think they're guilty of misrepresentation all the time, but to actually prove that type of tort, the plaintiff must be able to prove that the harm suffered was a direct result of relying on the opposing party's misrepresentation. Not that you kind of sort of thought something, it kind of looked the way you thought. Somebody has to actually say something that's not true, and you relied on it. Now, it's not only actually saying something true, it's also omitting a material fact that's obvious under the circumstances, an important fact during the negotiations. The other party was harmed. So let's say you're selling what appears to be, I don't know, something, an antique or something, some kind of piece of furniture. And you're not saying it's an antique, but you're really leading to believe them, and you're omitting it. That could also be some sort of misrepresentation. Now, I think lawyers get misrepresentation claims. Clients call all the time for that kind of stuff, because what's really a material misrepresentation and what's not is often in the eye of the beholder. What a jury's going to think is material and what a person may subjectively think of it is two different things. We can come up with that kind of scenarios all the time. I'm sure you guys have seen things that you felt were out and out fraud or misrepresentation.
Let me ask you guys.
That's what Kurt says.
Let me ask.
Sorry, I go to that all the time. That was the example I was going to use, but okay, go ahead.
Okay, first of all, Ron, let me ask a couple of questions here. Would you classify the O.J. Simpson civil lawsuit in California tort situation?
Yeah, yes, I would. From what I remember about it, it's a tort situation, because there are intentional torts, battery, assault. Those are all intentional torts. So in order to recover, now, just like we spoke about before, since the Goldman family sued O.J. Simpson, they have to come up with something. You can't sue another individual for a crime. Only the state or the federal government can prosecute somebody for a crime. So in order to sue somebody for like that, yes, it's a tort suit, and that's exactly what it was.
Not that it was overly that collectible. They took away his Heisman Trophy or whatever they were going to do with it, but but that's either here or there. Another thing, you talk about misrepresentation, Ron. Would you say that that happens a lot in real estate, where real estate agents will not measure the house properly, and then you end up having to find out that they have to modify things? I would think that would probably fall into that, wouldn't it?
It depends on what the agent did. If the agent out and out said, let's say the agent had knowledge. Let's say the agent had knowledge that the house was, let's say, 2,000 square feet. And the agent says, this is a beautiful 2,200 square foot house. That would be an out and out misrepresentation. Now, let's say on the other end, you could do it by omission. The real estate agent knew the house is 2,000 square feet, but the real estate agent somebody said, so how many square feet is this? Well, I don't really know. That's an omission. So it could be either way.
See, many years ago when I owned a cottage out in Beaverton, Michigan, that actually happened to me, and obviously, we had to go through some paperwork to get that modified. That I thought I was buying a 1,000 square foot place, and it ended up being like 850 square feet or so. And when you have a smaller place, it's how you screw it up. Well,
that's a big difference.
Yeah, well, no, it really is, and it's a cottage on the lake. Really love the place too. Of course, I ended up having to sell it after about a year or two after I fixed it up. But I've always wondered whether real estate could fall into misrepresentation. One only knows that we've been dealing with a lot of different real estate agents with our groups that we belong to.
Oh, yeah, I could definitely. And Florida, I mean, since we're talking about Florida, misrepresentation is a lot of things going on. I mean, whether, senior citizens are scammed, or property scams, or business scams, investment scams, it goes on and on. I mean, misrepresentation, unfortunately, is a common cause of action filed in Florida because of the environment that we live in.
Well, yeah, Florida is obviously as we put it in general terms, Florida's scams. You couldn't count that high, but yeah, I can appreciate where you're coming from. Go ahead.
Right, and what is scam? It's pure misrepresentation.
Exactly. Go ahead, David. Those are a couple of things that came to mind.
Let me ask you this, because it popped into one of our conversations we had before. Sorry, we went on the air. The rulings are made based on the statutes and what has already been established in the state of Florida. But statutes aren't necessarily drawn up every day. But there are different instances where there's question is whether there's a validity to a case. So how do you determine what is a statute that's established where they're making a ruling on it? Is there any how do I want to say it? Is there any reason for them to create a new statute based on a court case that you're hearing maybe for the first time?
Well, yeah, it does. The Congress or the legislature of the state will determine that a statute needs to be constructed because maybe there's not a really good remedy, or a case comes out and they feel that's not really the best thing for society in a public policy sort of way. So the legislature will write a statute. Then it goes the other way. Then they have a statute, and then the courts have to interpret it. Because the statutory interpretation, it's not a tort, but statutory interpretation is a big area of law. Because just because the legislature writes a paragraph, okay, what did they actually mean? And that goes into a whole nother issue. And then you got the common law, like torts are common law based. They go back, believe it or not, some of these torts go back to England, hundreds of years ago, and we just absorbed them when the U.S. became independent. And then you got to look, and that's what cases, they look at old cases and find analogies and find similarities and analyze cases and how does this apply like it applied then. And it can go round and round for a while, that's for sure.
Two more questions and I'll kick it back over to Scott. First of all, when you're talking about contractual obligation, I know it's a different situation. Are there civil suits that maybe apply to the sports world, especially now, where athletes are feeling that they are getting wronged, or, owners are saying, well, he didn't play to the best of his ability? Or do we find that those kind of cases happen within the sports world?
I do think those kind of cases happen in the sports world. But with collective bargaining, you're usually looking at arbitrations. So we don't always know everything that goes on because arbitrations are private. But yeah, I mean, if you think about it, it's a contract. When a player signs, they sign their contract to perform for so many number of years for so much money. And there's different things and incentives on the other side. So there's disputes, no doubt about it.
Okay. Sorry about that. I'm playing injured tonight, guys. I'm really pulling through.
You're doing a fantastic job, considering.
Thank you. okay, when somebody comes to you and says, the window in my apartment is broken. I'm talking to my landlord, or I've talked to the rental company and whatnot, and they have not fixed it yet. What do I do? What kind of advice do you give to people that, these are important things. I mean, living comfortably is important. Recouping the loss of property or money or job or whatever is important. What kind of advice do you give to somebody who maybe doesn't understand all the facets of what goes into it?
Oh, absolutely. First, I say, because that's a landlord-tenant situation, I would say we need to get you a landlord-tenant attorney. But there's a couple of different things you look at. You look at the statutes, because Florida has a residential tenancy statute, which has certain obligations that landlords must follow, and safety and health are included in there. So that they might violate the statute. Then they look at the lease. Did the landlord violate lease obligations? And then you kind of put those two together and see what the claim is. Something like that, I think there will be a cause of action. I mean, it should be repaired. The landlord has an obligation to repair something like that, I would say.
Great. Scott, you want to jump in?
Yeah, I would. We talk about a lot of things dealing with Florida, but are there any particular, let's talk about any examples that you're dealing with tort that might apply to unions, you know what I mean, and more industrial states. Can you name some examples of some of those?
Well, sure. Actually, there's a couple of those. One would be tortious interference. And that is, even though it's a tort, it deals in a roundabout way with a contract. There are two ways which a third party can interfere with tortious interference. And that is, a third party interferes with a contract that's already been formed between two other parties. Or a third party can interfere with a prospective business opportunities between parties. So let's say that we have a contractual situation. Let's say you guys each have a contract for, I don't know, broadcasting. You guys might do something like that. So we have a contract for broadcasting, and I want to lure David away. I know you guys have a contract, but I go and I kind of try and woo him away. I try to get him to leave you, and I say, hey, break the contract, I'll pay you more. If I'm aware of the contract, you could sue me because I'm aware of 5 different things have to be proven. One, a valid contract existed between you, the plaintiff, if you sued me, and the other party, David. The third party, meaning me, I knew of your contract. And then I acted in an intentional way to persuade David to breach his contract. Like, come on, don't worry about that contract. Just break it. I'll pay you, I'll pay you 20 cents instead of 10 cents. And then there has to be an actual breach by the contract by the party. So say David does do something. He leaves. And Scott suffered damages. He suffered damages because he lost a fantastically valuable host. That would be tortious interference with contract. It could be negligent or it could be intentional. So that would apply strictly in the business context. Another one strictly in the business context would be what's called breach of fiduciary duty. Now, that is when a party is responsible to act in the best interests of a beneficiary. In the corporate example, a traditional one everyone thinks of is the executive of a company has a fiduciary duty to the shareholders, meaning they have to act in the best interest of the company, so they will to protect the assets of the company. So the executive under this duty must act in the best interest of the company's shareholders. They act in a manner contrary to the best interest of the shareholders. They commit a breach of fiduciary duty. Let's say there's a car company. Michigan has car companies. This car company, the executives are supposed to act in the best interest of the shareholders, not themselves. Let's say they do something to enrich themselves that actually makes the stock of the company go down and make it worth less. That's an action that the shareholders can sustain against the executive for breach of fiduciary duty. Now, fiduciary duties can come in many ways. You have a financial planner. That person has a fiduciary duty to you to protect your assets. You have a real estate agent. That person has a fiduciary duty to you to sell your house in a proper manner. those kind of duties are created all the time, and those are probably the biggest business-related torts that I come in contact with, and unfortunately, there's a lot of them out there.
So do you find yourself dealing with torts pertaining to insurance companies? If there's ever an industry that has a black eye at times, it's insurance companies, because they find ways to get out of claims or raise their rates or however they're going to do it, because, the insurance business does not have that great of a reputation.
Yeah, 100%. And you're right. Yes, you deal with insurance companies. You deal with it all the time, whether it's the opposing party's company, but a lot of people deal with their own companies. They deal with something called bad faith, and the statute, Florida even has a statute on it, that insurance company won't settle a claim in good faith, meaning they're acting in bad faith, meaning they won't offer a reasonable amount of money or they won't cover the damage that you sustain. And the insurance company's goal is to not pay money. And a lot of times insurance companies would rather litigate a claim and drag it on just to delay paying the money. I guess it's part of the business model.
Well, since we reside in the state of Florida, how could I go without making a hurricane season reference in terms of how ugly some of those claims could be?
Unfortunately, you cannot do that. Unfortunately, you cannot do that. Now, if you're successful in a claim, what do you get? It's money damages. The harm party gets money damages. Now, it's usually the actual damage for the loss that the plaintiff sustained. There are some circumstances where a judge can also order a defendant to pay punitive damages, which for truly, really bad conduct. And a judge may also issue a permanent injunction directing the defendant to cease and desist from whatever the conduct is. Now, when you go back to damage and you say the actual amount of loss, and people don't really understand that, and when they get into a tort situation, they think, well, I'm going to make a windfall, and the law is not designed for that. It's to make you whole. So let's say you have a business and you lost $10,000 in profits. You're not going to get $1 million. And even in the negligence, the personal injury aspect. I mean, somebody, let's say the old slip and fall we talked about, they want to be compensated for the pain and suffering, their medical bills, but it's not to make a profit. And sometimes you unfortunately you see people say, "Hey, Sue, you're going to get millions," and it doesn't work that way. It's not designed to work that way, actually.
I mean, I've dealt with a personal injury situation, and for those people thinking it's a quick way to make a buck, unless you're in an auto accident and the insurance company knows you have to pay, it's a long, drawn-out process where the stress you have to go through, the arbitration hearings, and so forth is tedious. Years ago, I did suffer a slip and fall situation up in Orlando at the old Orlando Arena, and I'll tell you what, it took me many years to get it done, and everybody would think that going up to Orlando, you go to Disney World. Most people, yeah, but not in my case. It was either a courtroom or an arbitration room. And that drive down the Florida Turnpike was normally a pretty frustrating drive where you're biting your tongue and your lip. It wasn't fun, but it was something I had to deal with because it ultimately led to a L4, L5 operation where I had 2 cages inserted. So, no, Disney World wasn't fun. The Florida Turnpike stunk, but I still had to deal with it because I was dealing with a large company that didn't want to pay. In fact, I have no problem talking about the fact that Levy Corporation tried as hard as they could to not get out of paying it, but I had I had a decent lawyer, and the one thing I had going for me is since I'm involved with the media, places like that don't like bad publicity. I was about to make sure that they got it if they didn't settle after all the aggravation I had to deal with. But that's another day for another time.
Hey, that's only fair. You got to have as much leverage as you can on a defendant like that. And that's a prime example of what we're talking about. You were injured. I mean, that's a pretty severe injury. And it wasn't a windfall. They didn't just throw money at you. You had to fight every step of the way to get just what you were due. I hope you even got what close to you were due because, like you said, the defendant's goal is not to pay you money and to do everything they can not to pay you that money and drag it on.
I mean, with no disrespect, okay, I felt like I didn't get what I should have had. I don't know whether the fact, again, I'm not going to sit here and bash attorneys, but because the one I had was all right, but but I settled on an attorney through a friend. He did what he had to do, but the main thing is I got my medical bills paid for, so that helped. And of course they negotiated the bills down a little bit, but nobody will say in hindsight do I wish I would have had a better attorney? Probably, but I didn't belong to the Coral Springs Regional Chamber of Commerce where I had a guy that would be better than what I had, but he was sufficient. But again,
that's right. You could always go to one of the great attorneys that are members of the Coral Springs Coconut Creek Regional Chamber of Commerce. That's for sure.
So for those listening to this broadcast, we're giving you a free plug. I'll charge you.
It's free advertising at its best.
Yeah, it'll be the compensation will be future considerations. Make sure they're listening to the broadcast. So you never know, you'll be called at any time. No, but
you never know. And there's some really good personal injury attorneys in that organization. So, but you're right. That another free plug.
Right. Yeah. But no, I mean the attorney I had was sufficient. He came through recommended through a friend of mine that I know many years. But the main thing is I still walked away with some money. But more importantly, the biggest thing is I had my medical bills paid. So if for no other reason, it took many, many years to get it done. But I can appreciate where there is a lot of fraudulent activity that would take place with insurance companies because they're all looking to wear you down. It's not one of those little Rocky fights where I'm looking to go ahead and go the distance and I'm not going to get knocked out with a boneheaded settlement of say $17,000 when your medical bills were six figures. Yeah, they were. Let me tell you, they were. So, but again. I felt like I was Rocky, and I went there and went toe-to-toe with him and went to 15 rounds. So, but in the end, I don't want to get off too much subject. My main objective is that tort claims can definitely be dealt with through insurance companies. And do you find that those are quite common?
Oh, absolutely. And 100%. Tort claims are probably one of the most things that insurance companies deal with. Whether it's a property damage claim, you brought up the hurricane, that's a property damage claim. Whether it's, an accident, slip and fall, anything like that. And insurance company, and there's even, I've heard people are trying to bring claims based on COVID, based on loss of business based on COVID. Because we unfortunately know a lot of businesses have been going out of business or losing a lot of customers and income. And so there's plans out there. What they'll end up being, whether they'll end up working, I don't know. But it's a lot of creative attorneys are out there fighting the good fight on tort claims every day.
I like that. Creative attorneys, David. What's your take on creative attorneys?
Do you really want me to answer that? I know a bunch of people who are on TV, on sides of buses, who are quick to use social media for their own personal gain and then worry about their clients later. Not saying there's anybody on the show. I'm just saying I know a lot of people in Jacksonville that preach that vitriol, if we want to call it that. That's a whole nother show.
100% a whole nother show.
Yeah, but anytime you talk about creative attorneys, boy, I'll tell you, your mind can swell and go 9 million different directions. It really can, because of the fact that, we're dealing with COVID-19 during unprecedented times, and now we're dealing with creative attorneys. Oh my goodness, they almost have to probably write a new book for the bar, wouldn't they, Ron, dealing with creative attorneys for COVID-19?
Well, let me clarify. When I meant creative, I meant people, attorneys that are trying to help the injured parties and the businesses by investigating, how torts apply to the COVID situation, because we've never dealt with them before. You have to be creative. It's not like you can open a book and say, well, yeah, we had this COVID situation. I mean, yes, we had the Spanish flu of 1918, but other than that, there hasn't been anything in the intervening years that even comes close to comparing to this. So you can't go back to the insurance company and say, oh yeah, we have this claim based on COVID. It wasn't like COVID was written into the policy. your loss of business. So creative in the way of trying to come up with new law, essentially, when none existed before. Yeah, and creative could be in both ways. Yes, I will not argue creative could be a good thing and could be a bad thing. That I'm not going to argue with you.
Well, it just goes back to the old saying, let the imagination run amok, right? Oh, my goodness.
That's a good way to look at it. Well, that's what radio shows are all about, right?
Oh, yeah. Well, think about it.
And that's another topic to have. Definitely.
Hey, listen. I've been in media for 40 years, and I find myself not looking for specific guests right now because we don't have any games going on. So if there's ever a time when you have to definitely be creative, I'm definitely being challenged during COVID-19. That David talks about not liking soap operas. Okay, like As the World Turns. Okay, well, I'll just come up with a new one called As the Games Drop.
And that's true.
Nice, yeah.
Yeah, well, we're actually starting to get games. Well, whoever's listening, make sure they listen to the baseball show with Scott and David.
Look at that.
Enjoy it. Thursday night. Plug. It's Thursday. Make sure you're there. Be there.
There you go. Give a good plug. But as the games drop, that's been the story of 2020. I mean, they've all dropped like dominoes.
Sure. I like that, as the games drop. Yeah, I know. I like that. But that's true. Unfortunately, that's what we're living in right now.
But don't expect me to trademark that because I'm afraid it'll probably. I won't say as the games drop because it might take me until retirement to get that one through. After, let me tell you, thanks to you, Ron, I'm learning what trademarks are about, and I'm glad that I'm hopefully on the verge of getting one. But I'll tell you what. You want to talk about patience? Trademarks are definitely one of those.
It's patience. But it's coming soon. You're gonna be able to make that announcement very soon, my friend. Scott. You're gonna be able to make the announcement.
The vibes are good. So we let the imaginations run amok. So anything else you want to add about torts here, David? I hold my own with this conversation.
Actually, I thought we covered quite a bit of it. I like the fact that we're explaining common law. What I mean by that is that people do these things every day. And like I said, we're a quick to sue society. Hopefully that changes. But at least now we're making examples or explaining exactly what happens when you do have an incident for, a broken whatever, or, I slip and I fall, or gee, the street is cracked and I slip or whatever. These are things people do need to know about. So I'm really glad that we're able to talk about it tonight. Well,
what's amazing about the old day, we all talk about Florida being an interesting bird, but go to California, my goodness, it's not like...
I'm sure.
And I don't know about New York, but I know California is an interesting bird out there too. So go figure. I mean, I've dealt with...
We're not being New York right now because they're all quarantined. Nobody's outside right now. They're staying away from everything.
Well, it seems like nowadays everybody's quarantined because the numbers don't look like they're going down, and we can be dealing with the second wave, but that'll be for another broadcast. But, get me wrong, I love California, and I have a lot of ties to the area. But, Florida gets an interesting rap for what they're doing, but California is definitely out there along with New York. And, of course, we all know that Florida is known for its scams, but scams are all over the place. It just depends on, but they usually circulate in a lot of the warm weather climates, except in specific north cities around the country. So, I don't know, pretty interesting broadcast. I mean, to bring up O.J. Simpson, Ronald Goldman, reality, you could go out there and sue somebody, but it's one thing, Ron and David, are they really collectible?
That is always just Scott, that in a civil situation, you have to realize you can get a judgment against somebody, but getting the money from the judgment are two very different things. Somebody may not be collectible. You're absolutely right.
Well, let me bring up another.
The Goldmans did get a judgment against him. I don't know what the monetary value was, and I don't know whether they collected, but I do know they did rule in the Goldman's favor.
I believe that's true.
Yeah, but again, it's all about collectability.
But an issue of collectability is always an issue. Anytime you bring a civil case, you got to actually think about that. Is this worth it? Is this person going to file bankruptcy? something like that. You just never know. You just never know.
Well, if they filed bankruptcy, obviously you can't get your money anyways. Now that you brought that up, right, Ron?
Generally, yeah. I'm not a bankruptcy attorney, but my understanding is there's a lot of ways you can discharge debts, and bankruptcy is one of them. And Florida is a debtor. It's a good place for debtors. Speaking of O.J. Simpson, why do you think he picked up residence in Palm Beach?
Yeah, good.
So he could take advantage of the Florida laws that protect debtors.
Well, wasn't he in?
I was going to say something else, but okay.
Well, wasn't he in?
Where you find the killers? Come on.
Right, wasn't he? Yeah.
Well, they can look at it that way too.
Was O.J. Simpson in Dade County, Florida, in the Miami area, or was he in Palm Beach? I'm trying to remember.
I thought he was in Palm Beach, but I could be wrong. Why that clicks in my head, I don't know.
No, it doesn't matter.
I think it's Palm. I think Miami and Dade County wouldn't let him in. Honestly.
Really? Maybe you might be right. You might be right.
There are some counties that didn't want him there. I believe it's Palm Beach County.
Yeah, I thought it was actually Coconut Grove out in that area, but I don't know. We can look that up.
Oh, well, there you go. I am wrong, but at least I got the state right.
Well, no, that's okay.
Right.
Well, you guys brought up an interesting example, and it came to my mind. David, obviously being a football guy you are, there was an incident involving Fox Sports' Aaron Andrews with the guy looking through a room with a peeping thing. I think she ended up filing. Would that be another good example of a tort situation? Aaron Andrews, when they looked, I think they had a hole there, and the guy had a camera filming her.
It would be.
With her birthday suit on.
She was looking for damages of hand stuff, and
there
was a suit against the guy.
Right, yeah. So, I don't know.
Yeah.
You talk about different celebrities that are what they are, but I was just wondering if that fell into that category as well. I don't know.
It does fall into torts. Torts is such an expansive thing. When you don't really know what area it falls in, there's a good chance it is a tort. Definitely. And I believe that does qualify, yes.
Interesting. Well,
as far as I'm not sure, but as far as I remember.
Well, no, again, I think this is a really interesting subject matter. And I think it's a subject matter that people should definitely be aware that in a sue-happy society, you don't know what can happen at any given day, whether it's via the United States Supreme Court, Florida Supreme Court, or whatever. The court system, whether you have a president or not that is a dictator or not, you still have three branches of government. You have, obviously, the executive branch, the court system, and you have Congress. So, it isn't one of those societies where one person makes a decision, one man rules on everything. That doesn't quite happen in a democracy like this. So.
No, that's right, Scott. We're designed to have three separate yet co-equal branches of government. The beauty of the Constitution.
Yeah, it sure is. Well, the beauty of this show, folks, is you have an opportunity to go out there and learn a lot of things about Florida tort law, and as well as perhaps some examples outside of the state of Florida. So with that said, Ron, we're going to let you lead off and let people know how they can get a hold of you. Obviously, I should point out that Ron Renzy is the South Florida Tribune legal analyst. He represents us as well and helps me on a lot of things that I need help on. So go ahead, Ron, lead it off and let people know how they can reach you.
Thanks, Scott. I appreciate it. My firm's name is Wahlberg and Renzy. We can be reached at 954-757-1212 or by email at info@Wahlberg, WALLBERG -Renzy.com, on Twitter at Wahlberg Renzy PA, and on Instagram at Wahlberg Renzy.
All right, David, go ahead.
All right. It's been a great night, guys. Thank you for having me on again. I appreciate it.
You're welcome.
I write for Fansided.com. I cover the Miami Marlins on MarlinManiac.com. I also cover the Jacksonville Jaguars on BlackandTeal.com. I can be found on Twitter at DM719907.
All right. And as for us, well, you can reach us on Twitter at Tribune South. That's the @ Tribune South. Facebook, South Florida Tribune. Look us up, like the page, you get updates. Instagram, you can find us as well under South Florida Tribune. We have a YouTube channel that gets a little bit of work periodically with COVID-19. But with that said, please subscribe to South Florida Tribune and then you'll get updates about when and where we're at any given time. Their website is www.southfloridatribune.com. You can find content from our media distribution partners, columnists, and of course you can find our broadcasts as well on there under the WSAN network drop-down box. Email us at southfloridatribune@gmail.com. You can find me on LinkedIn at Scott Morganroth. You are listening to the South Florida Tribune podcast here on the WSAN network. And you can also find these broadcasts wherever you get your podcasts, and you'll find them on Apple Podcasts, Spreaker, Spotify, iHeartRadio, and Google Podcasts. Those are your main ones. So please subscribe to every one of the shows, and those, once again, you can locate those on the South Florida Tribune website. So great show tonight, Ron. Great show tonight, David. As usual, all the President's Men has a good cast of characters around him to make sure that we get the message out there.
Enjoyed it.
What's that?
Really enjoyed it, guys. Sorry.
You're very welcome.
I'm going horse here. I'm sorry, guys.
Well, you're going horse. Well, if I go horse, I'm in deep trouble. So can't afford to have that.
Scott.
What's that?
I knew as soon as I said that what you were doing.
Everybody's got to know what GMTA stands for, right, Ron and David? Great minds think alike. Hey, listen.
That's right, my friend.
Let me tell you something. I got to end it on this note here. When I had George Martinez on the Sports Exchange earlier, and we're talking about the Arena Football League, and I told him as a coach to tell his kicker, okay, and this came from me, and I know this guy is so sharp and he'll do it, okay. I said, pretend that the Arena Football League field goal, and if you take a Big Bertha golf club, and once upon a time, another lifetime ago, I played golf, you take that line, it's straight on Big Bertha, you hit it straight, you'll be able to drive it straight. So we treat the Arena Football League field goal like a Big Bertha golf club, I should say, on the golf course. And what do you have? A pretty straightforward situation. So just thought I'd go out there and give our friends at the Golf Network, Golf Channel, a little bit of a plug. Buy a Big Bertha. It's a powerful club, okay? And we feel like we gave you a powerful club verse of legal information tonight. So once again, on behalf of Ron Renzy and David Levin, my name is Scott Morganroth, the Motor City Madmouth, encouraging everybody, use common sense, mask up, exercise social distancing, because these numbers are not getting any lower. They seem to be getting a little higher. Please don't be on the wrong end of a statistic that you don't want to be on. So can't say any more than that. So guys, we look forward to the next episode of the South Florida Tribune. So once again, good night, everybody.